It is now 3:30 p.m. I am in Nairobi. A warm welcome from Jaslika to all our distinguished panelists and all our guests who have joined us from different parts of the world. Today I have the privilege of introducing to you 4 expert panelists who come from very, very different backgrounds, very diverse backgrounds and experiences, but they do have one thing in common. Their passion for justice, equality, peace, and the principle of non-discrimination. Today, they will be sharing their experiences and their views on different complementary strategies and mechanisms for promoting and protecting and respecting the rights of the child. So welcome once again. The 4 panelists we have today are Ms. Veronica Mwangi, who is the Deputy Director of the Kenya National Commission on Human Rights. For those of you, our international audience, who may not know what is the Kenya National Commission on Human Rights, it is a national institution mandated to ensure the promotion and protection of human rights in Kenya. Next on our panel, we'll have Dr. Saudamini Siegrist, who is an associate with Humanitarian Partnerships and Development International, and formerly a senior advisor for child protection in emergencies for UNICEF. We also have Dr. Kibaya Laibuta. He is the managing partner at the law firm Laibuta Associates and is the drafter of the Children's Bill, the Kenya Children's Bill 2020, which is still waiting for to be made into law. And finally, last but not least, we have Ms. Leslee Udwin, a human rights advocate and filmmaker who is the founding CEO of Think Equal. She will share her insights on early socialization and learning as a key channel for instilling human rights values in children. I also have with me my co-moderator, Declan Magero, who will share this platform with me and make sure we moderate your questions that you have, and interaction with you and the panelists is done effectively. In the background, we have a team moderating the questions, and they are from different parts of Kenya. Actually, they're all over, from different counties of Kenya. They are Jasmine, Conrad, Leila, Ernest, Wangui, and Naum. And then we have the technical people. This live stream is being done from Japan, Yokohama, Japan. It's being managed from there, and then we have Ali, who is also behind the scenes managing this session from Nyeri, which is a county in Kenya, outside, about 2 hours from Nairobi. And I'm Sheila Wamahiu, Director of Jaslika. I will be your facilitator today, together, as I mentioned earlier, with Declan Magero Ochich. So thank you once again for being with us. I'd like to get started with Veronica Mwangi. But before I do that, I would like to hand over to Declan to take us through the guidelines for your participation in this webinar today. So Declan, over to you.
Thank you very much, Dr. Sheila. It's a great pleasure to be co-moderating this fantastic webinar alongside you. the following are just some guidelines that can help us manage this webinar better and ensure that we have the best results out of it. So first is please refrain from making comments that do not relate to the topic or to what is being discussed by the panelists. Secondly, is the chat can also be used to ask technical questions. For example, if you're having issues with the sound, please feel free to ask about it in the chat section. You can also direct your technical questions to hello@jaslika.com. If the problem can realistically be resolved during the course of the webinar, then our team will do its best at what they can to resolve it. The third guideline is you can still write in your questions throughout presentations. Your questions will be compiled and passed on to the speakers at question time to ensure that, pretty much everyone's question is covered. The fourth guideline is when asking a question, please tell us where you're joining us from. That's your city or country, and your work or institution of affiliation, if any. Fifth, Jaslika is guided by the values of respect and diversity. Any inappropriate comments will not be tolerated. If you make any inappropriate comments, you will immediately, sadly, be removed from the chat by our team of moderators. Inappropriate comments include, but not limited to, personal insults, comments that are tribalist, racist, sexist, homophobic, transphobic, ageist, or ableist. Last guideline, we are reminding you that we are recording the webinar. Thank you very much, and great. Back to you, Prof.
Thank you so much, Declan. So with that, I think we can get started. And I'd like to introduce Veronica Mwangi, who is our first panelist. She will be talking to us today about the invisible children, with specific reference to the intersex children and the findings of the Kenyan Intersex Task Force and the advocacy and the outcomes. So basically, we are focusing on, her presentation will be on advocacy as a strategy for inclusion of children who are almost always overlooked. Ms. Veronica Mwangi is a Kenyan advocate with over 12 years specialized experience in human rights, family, civil, and commercial law. She holds a master's degree in business administration, strategic management option. She's a child rights advocate, certified professional mediator, an accredited court-annexed mediator, a trainer of trainees in various human rights thematic topics. Her work experience ranges from court litigation on child rights, human rights practice, mediation, public policy, and governance matters. She continues to coordinate Kenya's institutional reforms, advocacy on intersex persons' rights, and migration and human rights. She has served the country in various task forces and advisory committees, notably the National Council for the Administration of Justice, NCAJ, Special Task Force on Children Matters, National Advisory Committees on Counter-Trafficking in Persons, the Intersex Persons Implementation Committee, and now the defunct Intersex Task Force. Currently, she is Deputy Director in the Kenya National Commission on Human Rights, leading the Reforms and Accountability Department, which focuses on institutional reforms, advocacy towards infusing a culture of respect for human rights. Veronica, over to you.
Thank you, Dr. Sheila, and thank you for everyone and our listeners. And also thank you for this particular opportunity. I would want to first and foremost, of course, acknowledge the opportunity given. And with that, I will go directly to the message of today, or the topic of today, children's rights as human rights. From my understanding of this particular topic, I decided to look at it and give it a title that will also communicate to the intention of the call today. And I will be looking at children's rights as human rights, lifting the veil of the invisible children, a case study of the intersex children in Kenya. Free dictionary, which speaks to lifting of diverge to explain or reveal something that was previously a secret. In other countries in the world, intersex persons have been forced to live their lives in secrecy. I will go into a case of Mary Waithera, who is also known as James Karanja, the societal stigma and repercussions. His was a secret life at the behest of the society and all it stands for. Far off, but still within the African continent, we meet Mfaso from Zambia, who again was born an intersex person, raised as a girl, but eventually had to come to terms with his new reality. And on 17th April 2019, that is last year, he was able to open up to BBC about his being intersex. And in his interview, he stated that he had been forced to live a secret life because he could not bear the stigma that is faced by intersex persons in Africa. Many miles away in USA, we have the human rights report that has reported about medically unnecessary surgeries of intersex persons or intersex children in the US. Of interest for me is a case of a 60-year-old intersex woman in New York who was interviewed, and in addressing the silent rule of non-disclosure of intersex person, she gave an ordeal as follows. She says, my parents, the doctors did not tell my parents did not know that they had deemed me a pseudo-hermaphrodite. My mother was kept under sedation for 3 days when I was born, until they could tell her what I was. They just didn't want her to wake up and she was going to say, it is a girl or a boy. Or she was going to say, is it a girl or a boy? That's what it was. If they couldn't tell the mother what sex her kid was, they kept her under for a while. This again clearly stipulates that the silence and the secrecy that comes about, that surrounds the lives of intersex people, intersex children, globally seems to really manifest and indicate that there is need for us to do a lot of work in this, a lot of work to ensure that the voices of these vulnerable group of people is brought forth. And with this, we need to ensure that parents and guardians of intersex persons, oftentimes at the point of giving birth to an intersex child, they are faced with a lot of challenges that leave them lonely, confused, and also mentally destabilized. So I would go into who is an intersex person. I know most people would want to ask that question. Intersex person refers to a child born with unclear sex characteristics that includes ambiguous male and female genitalia, hormones, chromosomes, and gonads. This then makes it difficult for this child to fit in the current atypical male or female binary models that we have really adopted in the different registration systems. In the past, most people used to refer to intersex persons as hermaphrodites. This term is derogatory. Hence, the use of the new term intersex persons, which comes in to help us and to help every other person to communicate the need to uphold the human dignity of the intersex person. If you speak to the doctors, they will tell you about intersex condition, which again is a medical condition that affects the biology sex of a person. There are over 46 intersex variations. And according to one doctor, Dr. Ngatia, he says hormones are not assigned, they assign themselves. So why should we speak about intersex children? Are they different? Why not just go in and say and talk about intersex persons? Again, this is a question of children's rights as human rights. Just to reiterate that human rights are entitlements to every human being, and children in their own right are human beings, and so they have rights. The terminology that is used to refer to children's rights, it's only used to specify set of human rights that are specifically adapted to children's vulnerability, their specific age, and their specific needs and age appropriate. This again is to ensure that we safeguard their development as children. In Kenya, what have we done with regard to advocating or advancing the rights of intersex persons? There's a lot that has been done. First and foremost, I would go into the foundation. What was the basis of the government of Kenya putting in place a task force to advocate for the rights of intersex persons? This was really, it is a journey that the intersex persons have really walked, starting from legal battles, cases that were taken into court. All these cases, again, they were founded on the principles of the Constitution. That is the supremacy of the Constitution, where we go back and, of course, currently we look at, currently in Kenya, we look at the Constitution of Kenya, 2010, which really has provided a comprehensive and modern Bill of Rights that envisions a human rights-based and social justice-oriented state and society. In this regard, I would want to really reiterate that all stakeholders, state and non-state actors, everyone in the society has the ability and has the obligation to safeguard the rights of intersex persons, intersex children to be precise. Article 10(2)(b) of the Kenyan Constitution speaks about the national values and principles of governance that should guide us. Some of these principles include human dignity, equity, social justice, inclusiveness, among others. So allow me to go into just a bit of statistics about intersex persons. Globally, it is estimated that 0.05 to 1.7% of newborn babies are intersex. These are statistics that have been documented, also have been confirmed by UN Free and Equal campaign, a campaign that was initiated by the UN Office for Human Rights. Again, here in Kenya, we have Child Rights International Network that stated in court that they have documented estimates of 20,000 Kenyans who are born alive as intersex persons. Also, this is not forgetting the statistics that we have as Kenya. Recently, that is last year in August, Kenya was able to undertake a population census where 1,524 intersex persons were registered. Again, these numbers, 1,524, if you look at them and estimate them against the population, then we have 0.03. Does this mean 1,524 are the total intersex persons we have in Kenya? Not really. This is just indicative because these were the few people who are able to come out and to fight the stigma, and they got to be enumerated. So the journey about intersex persons advocacy in Kenya began in 2007, where the High Court was approached with regard to a case about an inmate, RM case, who was detained. The inmate was intersex person. The inmate underwent a number of violations, including discrimination. And so the court came in to really intervene, and the court was able even to uphold that this particular inmate was violated. So that is between 2007 and 2010. Then again in 2010, what happened? There was the process of enacting a Persons Deprived of Liberty Act, which in Kenya, it is the only law that has specifically addressed the issues of intersex persons with regard to even making an attempt to define who an intersex person is. Again in 2013, the court again got to sit and determine a case where a baby, the case is referenced as Baby A case. Baby A case refers to a child who was born intersex but could not access the legal documents that is required. The reasons being the sex marker concerns became apparent. And as such, within that Baby A's case, the court then gave directions that there was need for the AG to establish the plight of intersex persons, and to be precise, to identify the numbers of intersex persons across Kenya and the challenges they were facing with regard to care, protection, and management. And as such, that is how the Intersex Persons Task Force was formed in May 2017. It operated between May 2017 and March 2019. And during this time, a nationwide survey was done. And with this national survey, a report with key recommendations was submitted to the Attorney General in March 2019. And upon receiving this particular report, the Attorney General proceeded to form what we call an intersex persons implementation and coordination committee, which still is currently undertaking the implementation of these recommendations. Then on the other side, in August 2019, Kenya was able to at least get to document and enumerate the intersex persons in the National Population Housing Census. This being a first in the regional level, but also globally. And going on, I would want to speak to what were the specific things that the task force addressed in terms of the findings. The task force in its working was able to observe the following. One, the task force in its research and literature noted that most countries lack comprehensive data on intersex persons, including Kenya. And the population census documentation, or the population census enumeration of the 1,524 intersex persons was a step in the right direction. This happened after. But nevertheless, it was also observed that many countries have not put in place concrete policy, legislative and institutional or administrative system or structures that safeguard the rights of the intersex person. The task was also observed that 46 intersex conditions, the variations that I have alluded to, can be manifest at different stages. That is during pregnancy, screening, at birth, in childhood, and also during puberty and adulthood. Again, this is just to let us know that intersex process, even just the recognition of intersex person and status is not an event, it is a process, it's a journey that can occur at any stage of life. And in this regard, the intersex was able to propose a comprehensive definition of who an intersex person should be. And in my notes, I have that. I would be sharing the notes with Dr. Sheila for anyone who would be interested. But then the definition here speaks about intersex person as a person who is conceived and born with a biological sex characteristic that cannot be exclusively categorized in the common binary male or female due to their inherent and mixed anatomical, hormonal, gonadal, and chromosomal patterns, which could occur or which could be apparent prior to or at birth, in childhood, puberty, or adulthood. So delving further into the findings, I will just highlight the finding. The task force was able to find that most of the intersex persons suffer serious discrimination and systemic human rights violations due to the gaps that we have in our laws. It was observed that despite the Constitution of Kenya, Articles 2, Articles 19, 27, and many others recognizing and protecting intersex persons, the sectoral laws that we have that have been able to really institutionalize and operationalize some of these services and systems have a lot of gaps. And this is because these systems are fashioned along binary concepts of male and female. The sectors that are mostly affected are the sector of the registration of persons. That is where you have the births and death certificates being issued. Health sector, again, education, employment sector is also affected. Civil registrations, where you have the national identity cards issuance, social protection services, immigration, as well as access to justice. The other challenge that was observed, the other finding that was noted is that intersex persons status, when an intersex person or a parent gets to know or becomes aware of the intersex person status, oftentimes they face a lot of confusion and emotional drain that really affects them from that point going onward. And oftentimes you have intersex persons who are living or who have been socialized in different ways because of the skewed choices that were made by the parents, the guardians, and the birth attendants at the point of birth. Or the other side is with regard to access to healthcare, a total of 54% of the intersex persons indicated or ranked access to healthcare as poor. This is because these health facilities are again influenced by the prevailing biases and prejudices. The other one is on issues of access to the challenge on access to education. 57% of the intersex persons indicated that they have had problems accessing education. So they rated access to education as poor. And this again was because these systems again are built on prejudices in policies, laws, and systems. And I would just give a case here as we end. So this particular case here showcases the ignorance among caregivers in school environment and how this impacts on intersex children access to education, but also their human dignity. So this is a parent of intersex child says that she gave birth to this child and raised this child as a girl. But when this child reached puberty, this child became aware of her condition, and this affected her performance in secondary school. The head teacher of that particular school angrily called this parent and demanded that she withdraws her child from that school before she spreads her ujinga. That in English is to speak to stupidity to other students. So you can see here a caregiver in a school, someone we are supposed to trust in the system, in the process, to mold and to protect and safeguard this child, being the one who is perpetuating a violence or a violation. On the other side, a simple question that you ask any parent about choosing a school type for your child. Most parents will say it's a simple arithmetic. But for an intersex parent, choosing or making a choice about which school your intersex child will join. Is it a girls' boarding school or a boys' boarding school? Is it a day school or not? It's a mentally draining process. Ask an intersex person this question, and I can assure you they'll give you a number of considerations that they must put in place to ensure safety, but also welfare of that particular child, because every minute counts. The other few challenges that we came across was the lack of important registration documents among the intersex person. Again, this has also affected their access to education, employment, and even actualizing some of their rights. As simple as some of their rights, some of the intersex persons alluded to the fact that they are not even able to engage in mobile banking and even simple mobile money transfer processes like M-Pesa, among others, just because they don't have proper identification documents. And even those who have identification documents, oftentimes those documents do not represent their right sex. So you get people going and walking around with documentations, but in reality, those documentations are already contradicting and perpetuating a conflict of law. And most of them have either have in one way or the other been arrested for impersonation, among other crimes. So with regard to access to registration of persons, access to justice, intersex persons really noted, or they indicated that they have had a violation of their privacy due to intrusive and unnecessary searches. And the last one, with regard to suffering discrimination, intersex persons continue to suffer stigma perpetuated by the society due to the different customary practices, religious and professional beliefs and practices that we have, which again are built in the systems that are prejudiced. In terms of recommendations, what did we recommend? The issue of recognition and the access to legal document was highlighted, and the legislature was directed to facilitate recognition of intersex persons in law. Currently, the Intersex Implementation Coordination Committee is working with the Senate and the different National Assembly members to ensure that we actualize the inclusion of intersex marker in our laws, as this will really make it very easy for a mother who is today giving birth to a child who is intersex to not worry, to not go around thinking through what is the right choice they should make, after which years later they'll come and regret the choice they made for their children. And again, this intersex marker and the legal documentation will really help us to stop the unnecessary medical interventions that continue to come in, because these medical interventions, again, they bring in violations and so on. So in terms of the documentation, there is need to also lobby, and we are advocating for the inclusion of intersex marker in the different legal documents that we have. And also, with regard to public health, there is, I'm finalizing, with regard to public health, there is need for the Ministry of Health and the different actors to come in and join hands and ensure that we develop care, treatment and protection guidelines and protocols, and ensure that also intersex persons are able to access medical cover. Simple as the national NHIF, the National Health Insurance Fund, majority are out of it because of lack of documentation. Then the last one is about the medical interventions, the need for us to really have proper protocols that will guard against unnecessary interventions upon intersex children. The last one is the equalization fund, where intersex persons should be taken care of with regard to just coming in to bring equity and ensure that they are included in the process. Am I done? My time is over?
Yes, yes. Thank you so much. Thank you so much, Veronica. That was fascinating, because when we talk about intersex children, they're truly invisible. They don't have an identity at birth. They are assigned the wrong identity. They grow up with a lot of discrimination. Basic services are not availed to them. So I'm sure our viewers may have a lot of questions for you. And we will ask the question at the end during the Q&A. So thank you very much for that. I think what really stood out for me is the silence and secrecy that surrounds the intersex globally and in Kenya, and also the ignorance even within our education systems that continue to discriminate and exclude them from enjoying their rights as children and as human beings. So thank you. With that, I'll turn to our next presenter, to our next panelist. This is Dr. Saudamini Siegrist, to talk to us about issues of child protection and transitional justice. Saudamini is an associate with Humanitarian and Development Partnerships International in child protection. She served as a senior advisor for child protection in emergencies at UNICEF from 2012 to 2017, and previously as child protection specialist at the UNICEF Emergencies Research Center, and as chief of child protection for UNICEF in Palestine. She also worked in the Humanitarian Policy Unit of Emergency Operations at UNICEF on issues related to children and armed conflict, international criminal justice, and monitoring and reporting of grave violations against children. She was seconded to the Sierra Leone Truth and Reconciliation Commission in 2003 to 2004 as rapporteur and writer for Children's Truth and Reconciliation Commission report. She also served as lead writer for the publication Children and Truth Commissions, co-authored by UNICEF and the International Center for Transitional Justice. She co-edited the book Children and Transitional Justice, Truth-Telling, Accountability and Reconciliation, published by the Human Rights Program at Harvard Law School, and contributed to The Impact of War on Children, authored by Rasha Mashel. She holds a doctorate from New York University and a master's degree from Columbia University. So Saudamini, over to you.
Thank you. Thanks. Good afternoon. Many thanks to Dr. Sheila and to Jaslika and for today's invitation to join the webinar on children and human rights. As you noted, I'll be speaking more specifically about children and transitional justice. When UNICEF first started working on children and transitional justice, the question most often asked was, why children? What do children have to do with it? That's because transitional justice was seen as highly politicized with potential benefits, but also risks. The working definition, just to be clear, on transitional justice in the 2004 Secretary General's report is the full range of processes and mechanisms associated with a society's attempts to come to terms with large-scale human rights abuses and to ensure accountability, to serve justice and achieve reconciliation. So that includes both judicial and non-judicial processes, individual prosecutions, reparations, truth-seeking, and institutional reforms. There's a range of activities. But involving children in transitional justice didn't happen all at once. It evolved over time, and it's still evolving. So the answer, in short, to the question, why children, is that when transitional justice mechanisms address crimes committed against children in armed conflict or political violence, then children have an important role to play. That's because they are the victims and witnesses of the crimes and may also have been recruited and used in hostilities. In addition, as family members and citizens of their communities in their own right, children are partners in reconciliation and recovery. So in the early 2000s, truth commissions and international tribunals started looking at involving children in their processes based on the right to participation, as noted in Article 12 of the CRC, and also based on the best interest principle that is at the heart of the Convention on the Rights of the Child and maintains that all decisions should take the best interests of children into account. So how are the best interests of the child understood in the context of transitional justice? An interesting illustration of that point can be found in the decisions taken by the South African and the Sierra Leone Truth Commissions regarding children's participation in statement taking and in thematic hearings. In 1996, at the time the South African Truth Commission, there was a debate as to whether or not children, that means under age 18, should appear and testify during the special hearings on children and youth. There was no precedent for children's participation in such a process, and there were concerns that children could be re-traumatized as a result. Consultations took place with UNICEF and some 30 South African NGOs, and they concluded that the participation of children would expose them to too many risks and would not be in their best interests. And so children were excluded from participation in the statement taking and in the hearings. But 5 years later, in 2001, the Sierra Leone Truth Commission used the same argument, the best interests of the child, to arrive at a different conclusion. It was decided that because children were among those most affected by the civil war in Sierra Leone, their involvement in the Truth Commission was essential. It was determined to be in their best interests to participate. The question was not whether they should participate, but how to make their participation safe, how to make sure that it would be in their best interests. So participation and protection had to go hand in hand, had to be mutually reinforcing. It was necessary to put in place protocols and procedures that would protect children and provide psychosocial support throughout the process. A vulnerability assessment was developed, a safety checklist, a framework of cooperation between the Truth Commission and the child protection agencies. And it wasn't perfect, but children's views were taken into consideration in the accountability process, both in the Truth Commission and in the Special Court for Sierra Leone. And the decision of the Sierra Leone Truth Commission to include children resulted in over 300 statements from children and established precedent that informed the Liberia Truth Commission in 2006 to systematically include children in statement taking and in the regional hearings, with nearly 300 statements by children. More recently in Kenya in 2011, children were included in the Truth Commission with nearly 1,000 children giving statements, about 40 participating in the thematic hearings. So this evolution of thinking and decision-making with regard to children's best interests in transitional contexts means that the principle is not fixed or rigid, but should be adapted and informed by the local context, taking into consideration children's views and their experience as victims and witnesses. In 2003, I served as the rapporteur for the children's version of the Sierra Leone Truth and Reconciliation Commission report and worked together with the Children's Forum Network in Sierra Leone. That was a national group of children selected as representatives, also with the Voice of Children's Radio, the first ever Children's National Assembly. The kids we worked with were dynamic, engaged, articulate, and they were the driving force behind the report. That included girls, and although they faced greater challenges and struggled for equal voice. A very important point is that in statement after statement, the children expressed loud and clear their number one priority in the aftermath of the war. That was overwhelmingly education. They wanted education to access opportunities for the future. In 2010, when we did research on children and transitional justice, working with Harvard Law School and with a range of stakeholders, education was for the first time included in a transitional justice agenda. It had been missing. There was a gap. That's significant because child protection and education are community-based efforts, intergenerational, and they have a highly significant impact on long-term recovery. From 2012 to about 2016, as a component of UNICEF's peace-building education and advocacy program, case studies were conducted on education efforts that support and have supported transitional justice in the Middle East, in Asia, in Africa, Europe, Latin America, North America. And the case studies document both formal and informal education reform, including curriculum reform, teacher training, reparations, programs linked to education, recommendations by truth commissions on education reform, informal education projects addressing memory, memorial, legacies of the past. And it was determined that educational reform in child protection focused transitional justice efforts, engaging children in discussion and dialogue, are a key priority for transitional justice. And that the exercise itself, engaging children in discussion and dialogue in a safe environment, can build their skills in negotiation, critical thinking, and communication. So it's a capacity building exercise. The work that has taken place since that time, documented in Sierra Leone, South Africa, Liberia, Peru, Colombia, Canada, Guatemala, Kenya, Nepal recently, Sri Lanka, all point to that potential for positive impacts for children and for their families and communities. There's a new handbook on political violence and children coming out by Oxford Press in September that highlights in particular interventions and preventions dealing with children's involvement in these contexts. But it's not a quick fix, and there's no formula. Building peace and establishing human rights and a safe place for children to realize their potential in the aftermath of violent conflict is a long haul. In all cases, the journey must be owned by the community, by families and children themselves. So a few takeaways on lessons learned to keep in mind. As we said, children are key actors in accountability and reconciliation processes. However, this does not mean that the burden of justice and truth seeking should be shifted onto the shoulders of children. It should not. But children should be given a place and a voice in those processes. Children's recovery from grave violations does not begin or end with transitional justice. Entire lifetimes may be spent in the effort to reconcile and to recover. We talk about genuine participation, the ladder of participation, the importance of child-led participation, and so on. But when it comes to transitional justice, the mechanisms are inherently political. So that should be recognized. What is the appropriate platform for children? This question came up in Nepal when a truth commission was proposed as part of the peace agreement at the end of the civil war in 2006. And to this day, it hasn't been convened. But the young people we met with in discussions were not in favor of a truth commission or any commission for that matter. They were disillusioned by too many broken promises. What happened instead was a national youth dialogue, which provided a platform for children and young people to reflect and engage. Also in 2010, UNICEF and the Human Rights Program at Harvard Law School published the key principles for children in transitional justice, which outline the protocols and protections needed so that children can participate safely. For example, the best interests of the child should guide children's participation from start to finish, and the safety and security of the child is paramount. Under no condition should be compromised. So the direct participation of children should be conducted only when there's physical protection and psychological well-being fully supported throughout, together with the child's family and community. All participation must be voluntary with informed consent of the child and the child's parent or guardian. So it's up to the child and the guardian to decide for themselves whether to give testimony. And a child may change her or his mind to decide to withdraw at any time. A decision not to participate is also participation. Children's participation, this is important, must be realistic and realizable and meaningful from their point of view, because raising unrealistic expectations leads to frustration and it can be damaging. Special attention is needed for girls to address their specific needs and vulnerabilities, in particular girls who've been targeted for sexual violence. And children's statements or testimony in a truth commission or in a court should be in a child-sensitive environment. Children's names and identities, and all testimony should be confidential. There was the case of the first trial at the International Criminal Court prosecuting the crime of child recruitment. The first witness called in that case was a child who testified in open court against the defendant, Thomas Lubanga. The protective measures employed did not include shielding the witness from the accused. And after testifying in the morning, the witness, a former child soldier, returned after the lunch break and recanted his testimony. The child was distressed, intimidated, and fearful. After that, witness protections were put in place by the ICC, and they developed a policy on children with protection protocols for the best interests of the child. Also with the understanding that child witnesses should be called to testify only when there is an absence of other evidence. So I'm going to wrap up now with just 3 points, and then hopefully we'll get to address other points in the Q&A. First, the participation of children and young people in reconciliation and peace building is a proven, tried, and tested course. The kids have made the case themselves. The second point, that transitional justice cannot be imposed or determined by an outside or international agenda. So the international community has to step back and let those who experience the violence find their way to come to terms with those experiences and rebuild. That's the message of local, traditional, indigenous processes, the need to be determined by local contexts and led by local actors. Lastly, international support is needed and may be indispensable in some situations, but as the rapporteur and writer for the children in Sierra Leone who participated in the drafting of the children's version of the Truth and Reconciliation Commission report, I have to say that the children I worked with did not need anybody to tell them what to do. They needed opportunities to express themselves and to put their ideas into action. In fact, many opportunities were lost along the way, so we can't really afford to give up. We just have to keep trying and learning and letting these processes evolve in the best interests of children. That is not to say that you cannot accomplish transitional justice without children, but if you leave children out of the picture, the loss will be significant and it may have serious consequences in the long term. Thank you.
Thank you so much for that, Saudamini. I think there was a lot in it that we need to digest and understand. You've talked about lost opportunities, and we really cannot afford to lose any more opportunities because the consequences can be disastrous. I'd like to ask you one question now, and then later we can come back to more questions. And just at this point, just take maybe 2 minutes to answer the question. And you could expound on it later, but just give us the essence of the answer. So this is a question from Iqbal from Nairobi. And he asks, how do the children who have committed violations make peace or reconcile with the victims and the community? And do they face any kind of legal responsibility for the actions?
Okay, that's a very complex and important question. And it's been a debate in the years of pursuing the participation of children in these processes. I should mention, first of all, the CRC does not set a minimum age for criminal responsibility. That's a national legal determination. But when it comes to international crimes, and that's what we're dealing with in this context, according to the Paris Principles, which is a very important norm and standard in this regard, children under 18 accused of crimes under international law, allegedly committed when associated with armed forces or armed groups, should be considered primarily as victims. So that's the idea that in reconciliation, I mean, there are options like restorative justice. There's no one set way. It's also important to note that the International Criminal Court does not have jurisdiction below the age of 18. So they don't prosecute for children. Children are not to be understood as having primary responsibility in the perpetration of these crimes. Interesting also, the special court in Sierra Leone was mandated to prosecute to the age of 15, but the policy of the court taken by the chief prosecutor, David Crane, was not to pursue criminal responsibility below the age of 18 because it was understood that children were not among those primarily responsible for the crimes that were committed. So the involvement of children is, it will be dependent on a specific situation, but these are the, let's say, trends in addressing the situation for children, that they should be primarily considered as victims. That's not to say they don't have agency, they do. And in accordance with their evolving capacities, that's Article 5 of the Convention. And by the way, I should mention this new issue where over 40 countries have actually passed new legislation or laws in for foreign terrorist fighters. And that frankly jeopardizes child protection by Children's Association forcibly recruited or in other ways influenced. So again, just to sum up, it depends on the situation, and there can't be one answer to that question. It's a very complex question. Primarily, we are looking for reconciliation and for the recognition of children as primarily victims of these of this conflict, violence, and crimes. Yeah.
Thank you for that, Saudamini. That was very interesting, and I'm sure we will carry on with this discussion. It's a very complex issue, as you said, especially now when we see children are forcibly recruited into as terrorists, as child soldiers. So should they really be prosecuted for something that they may not have fully understood and they may have been forced into doing? So thank you very much. We'll come back to you later. You want to add something? No, that's okay.
Well, just that the kids I work with, I mean, a number of them are really leading advocates on these issues now today, 10 years later.
Mm-hmm.
Yeah, what they can bring to the discussion and the understanding. Yeah.
Okay, thank you so much. So let's move on to our next panelist. And this is Dr. Laibuta, Dr. Kibaya Laibuta, who is going to focus on policy and legislative responses. Dr. Laibuta is an attorney at law and the managing partner in the firm Laibuta Associates, which is based in Nairobi. It's a firm that drafts, it's a firm of legislative drafting consultants and law attorneys, mediators, and arbitrators. And the principal place of business is Nairobi, Kenya, which I already mentioned. He is a renowned author, legislative counsel, chartered arbitrator, and a fellow of the Chartered Institute of Arbitrators, UK, with a wealth of experience in constitutional law, human rights, family law, and children's rights, which is why we've asked him on the panel today. Dr. Laibuta is the founding dean and senior law lecturer at the University of Embu Law School in Kenya. He served as a commissioner in the Commission for the Implementation of the Constitution in Kenya, the one that Veronica referred to, the Constitution 2010, and as a member of the National Council on the Administration of Justice. He also served as technical advisor to the Rules Committee of the Judiciary on legislative drafting. Dr. Laibuta drafted the Children Bill 2020 and the requisite rules and regulations for the operationalization of the statute law on children's matters in Kenya. He studied at the University of Nairobi, Kenya School of Law, the London School of Economics and Political Science, University of London, and at the International Law Institute in Kampala. So welcome, Dr. Laibuta. I'll hand over to you. Thank you.
Thank you, Sheila. I believe you will all agree that children and human rights is a fairly fascinating subject, not just for discussion, but things of concern to the community of nations today. And there's reason to say this, because the community of nations, global community recognizes that all human beings are born free and equal in dignity and in rights. That is why, again, the golden thread that runs through legislative frameworks globally, the golden thread is this: for every child, every right. How, though, do we ensure that every child enjoys these rights and freedoms that are enshrined in various treaty instruments at the UN level, at the regional level? A further step must be taken. But let's say a little about the Convention on the Rights of the Child, which provides the needed platform for the promotion and protection of the rights of the child. Ratified in 1990, this is perhaps the most widely ratified convention. Now, the convention lives up to the popular slogan that I've already mentioned: for every child, every right. What does this convention do? It gives effect to the fundamental rights, the fundamental human rights that are already enshrined in various instruments, which I mentioned again very briefly. It gives effect to the foundational UN human rights instruments. And we are all familiar with the UN Declaration, the Universal Declaration of Human Rights, the UN Convention on Civil and Political Rights, the UN, the Covenant on Economic, Social, and Cultural Rights. I take them a step further by paying special attention to children. Now, the Convention on the Rights of the Child constitutes the international agreement on childhood. And there is reason for focusing on childhood, because it does recognize that childhood as a special stage in life that requires special care and protection, requires special assistance. It recognizes that the family is indeed the fundamental group in society for the growth and development of every individual, especially children, who again have special needs that close attention should be paid to. And that is why children need to grow in a family environment. And you find that the law in Kenya does focus on that specifically. Those principles, golden thread that I've spoken of, informs Kenya's policy and legislative framework, the administrative frameworks, the institutional frameworks that are quite comprehensive in making sure that children's rights are accorded effective protection and promotion. Now, the legislative, institutional, and administrative frameworks, of course, in Kenya, uphold the rights of the child that are spelled in the Kenya Constitution. When you look at the 2010 Constitution promulgated way back in August, 27th August 2010, you find that the fourth chapter, chapter 4, provides a robust Bill of Rights that applies to just about everybody. However, Article 53 in that chapter pays special attention to children. Article 54 addresses itself to persons with disabilities, including children, of course. And with this regard, then you find we have the Persons with Disabilities Act that has quite some expansive provisions on children, their rights, their well-being, children programs to ensure that as children with disabilities, they enjoy special attention. Because that bill is under review presently. It has just recently been accorded the cabinet approval. And when it comes law, again, you'll have enhanced legislative framework on that front. Article 55 deals with the youth. Again, fairly important because the youth, how we define it, I'll not attempt to define it here, but it includes ages of children, from 16 upward. And then you have Article 56 that deals with minority and marginalized groups, among them children who have special needs depending on the kind of communities they come from. If those communities are marginalized or constitute minority groups, again, children need special attention. Their circumstances of those groups impact on children much more than they do on those who can survive on their own. Now, coming to the Children Bill of 2020, we started working on this piece of legislation way back in 2017, again, to give effect to the Constitution and to the dictates of the Constitution as regards the rights, the basic human rights and freedoms that are available to everyone, but more especially to children, and therefore the need to ensure that this is done in a more effective way. Of course, taking forward the provisions of the 2001 Act, which is still in force, but revamping the legislative framework on the rights of the child. Now, the bill, of course, is designed to give effect not just to the Constitution, but also to the Convention on the Rights of the Child. And when you look at its provisions, you will recognize one thing, that every right that is guaranteed under the Convention is given effect by providing the duty bearers, the house, and the effective breach or violation of those rights. The other thing you will note that the Convention is part of the law of Kenya by virtue of Article 2, Subarticle 5 and 6, Subarticles 5 and 6 of the Constitution, which imports into the domestic law every treaty instrument that Kenya is part of. So the Convention of the Rights of the Child is as good as the statute law in Kenya. And therefore the bill, the 2020 bill, seeks to give effect that as well in a more comprehensive way. The Children Bill is supported by subsidiary legislation. Now, the subsidiary legislation contains rules and regulations that tell us how, when, who should be doing what to give effect not just to the convention, but to the constitution that imports the convention into the law of the bill. It's the procedures that tell us how to go about the court and administrative functions, the undertaking of administrative functions by the executive on matters of adoption, matters of foster care, matters of guardianship, the appointment of guardians, care and protection of children in need of care and protection. It deals with children in children's institutions, setting standards and ensuring that the registration and management is for the best interest of the child. Then, of course, children in conflict with the law. What you find in both the bill and the procedural regime of the subsidiary legislation is a very well-defined framework of rules and regulations that tells us how to deal with child offenders through diversion, how we deal with children who have to be rehabilitated by reason of the fact that they committed certain, they offended in certain ways, so that we remove our children from the criminal justice regime and place them in a process of diversion that is both restorative and rehabilitative, so that we don't treat our children as criminals, but that although they are offenders, we need to treat them in such ways as will reform them and serve their best interest as they grow and develop. Part 2 of this bill basically deals with the basic human rights and freedoms that are recited in the Constitution. And these provisions are not merely declaratory, they go further to show who the duty bearers are and what they should do to achieve these rights and what should happen if these rights are violated. Now, very, very quickly, these include the right to the highest attainable standard of health, the right to education, the right to social security, the right to leisure leisure and recreation, which of course is the one thing children need all over the world. And the right, of course, to protection from child labor, the right to protection from sexual abuse and other forms of abuse, cyber crime and so forth, the right to liberty and freedom of movement, the right to life, the right to legal representation in proceedings. Now, when we talk about the right to legal representation, you recognize one thing, that the Legal Aid Act is quite extensive on who should enjoy legal representation, legal services at the state expense. Children feature there. And I was privileged to draft the legal aid regulations. And at the same time, I was drafting the children bill. So I made sure that children get the maximum attention when it comes to legal aid. Now, the objectives, of course, of the legislation, the administrative and institutional frameworks is really very straightforward. First of all, promote the best interest of the child. And you find this as the basic principle that cuts across both substantive legislation and the subsidiary legislation comprised of the rules and regulations. The other objective, of course, is to achieve the universal standards of care and protection of children. Again, mirroring on the Convention on the Rights of the Child, and also borrowing on the best practices globally, seeing how others in other comparable jurisdictions, whether Commonwealth or otherwise, see to it that these high standards are achieved. Again, to enforce the principle of accountability, social accountability, and we are all accountable to the duty, for the duty to give care and protection to our children. The things we do in the various child welfare programs, in education, in health, in exercising our parental responsibility, matters of adoption, foster care, the children institutions, all of us have a social responsibility to be accountable. Again, the legislative framework, the frameworks are well designed to support human rights approach to programming, because we do appreciate that all these cannot be attained unless effective programs, plan, and actions are in place to ensure that children indeed enjoy the rights and freedoms that the global community ascribes to them. Also to promote family-based care. This is another theme that runs across the substantive and subsidiary legislation. Also to guarantee child welfare programs that are effective for the growth and development of our children. Also to guarantee the child's right to survival and development, again, which is very closely tied up to the right to life, the inherent right to life. Also to promote, or rather to ensure the protection of children in need of care and protection. One thing you find in the bill is that it has a big list of who are considered to be children in need of care and protection. I'll mention only two jurisdictions that we looked at. Of course, we looked at various states in the United States of America that have very good programs for child care and protection. Canada as well, the UK, but New Zealand really stood out. It's one of the jurisdictions that has a set of legislation, a very robust legislative framework for the care and protection of children. And we single this out because the one thing we realize is that the rights of the child are secured by quite a number, multiple sets of legislation, including the Child Commissioner Act of 2003. You have the, which one is this? The Children Young Persons and Their Families Act. You have other pieces of legislation that pay keen attention to children. The Care of Children Act, the Education Act again. Of course, that goes without saying. The which one is this? Yeah, the New Zealand's Bill of Rights. Again, focusing on children in its provisions of the Human Rights Act as well. Quite a number, I must say, including the Official Information Act of 1992. When you look at African countries, South Africa also stands out, but in South Africa, we have a constitution that's quite comprehensive on matters of human rights and setting up, of course, the Human Rights Commission that pays special attention to matters relating to children. That is not to say that other jurisdictions don't pay attention to children, but they do so with varying formats in their legislative, administrative, and institutional frameworks. That's all I could say in 10 minutes. I'm sure I have overshot my time, but
thank you so much, Dr. Laibuta. Yes, there's a lot to talk about.
Absolutely.
But I'm sure we will be able to thrash out some of the issues that you have not been able to cover now in the Q&A section. Our audience must be having very many questions. I just want to ask you one very quick question, because you have Veronica talked about the intersex children. the children's bill, does it recognize intersex children? Because we know in the Kenyan constitution, it was a little bit controversial, the whole issue of sex and gender, if you remember. So
Yes.
what happens to intersex children in the children's bill?
Yeah, we were ahead on that even before the final report. And I remember when I was at the middle of the drafting, I met one of the intersex young men, and we had a chat at a conference. We just stood aside and had a lengthy chat. What Veronica has presented is precisely what goes on with our brothers and sisters who are intersex. The bill does accommodate them as children in need of care and protection. And by the way, when you look at the persons deprived of liberty, and I was also privileged to lead the technical team that reviewed the initial piece of legislation, beefed it up when I served at the commission. We took good care of all these special interest groups. All along, we've been open even when the national policy did not lend recognition to some of these special interest groups. But we knew that once we put it into law, it will carry the day, and that whether we have a defined national policy or a specific piece of legislation that addresses them, they will have been accorded protection elsewhere. And that's what we've done all these years.
Thank you so much. And you did touch upon children in conflict with the law, and I think that includes children who are arrested on grounds of terrorism. I don't know whether they're covered in the children's bill.
Yes.
And the rights safeguarded.
Yes, they are. Children in need of care and protection include, the long list I talked about includes children in situations of armed conflict. And those are covered there. Includes children who are refugees, internally displaced persons. We try to make sure that we do not exhaust this list. You see, when you have a list, there is always an end to it. But you'll always end up talking of such other children as are deemed to be in need of care and protection. So they are covered.
Okay, thank you so much. I think we'll just stop there. Thank you very much. And now finally, but not least, Leslee Udwin. And Leslee will be talking to us about we've been talking about different strategies. And Dr. Laibuta talked about every child, every right. And I think that is what Leslee is trying to do with her work. Every child, every right, from the earliest years. So she will talk to us about how human rights values can be instilled, children can be socialized into human rights values from the earliest years. So let me introduce her. It's not easy introducing Leslee. So, because it's very long. So I'll try my best. So Leslee was voted by the New York Times as the #2 most impactful woman of 2015, second to Hillary Clinton, and has been awarded the prestigious Swedish Anna Lindh Human Rights Prize, previously won by US Ambassador Madeleine Albright. She has also been named Secretary of State, actually. She has also been named SAFE's Global Hero of 2015, Global Thinker by Foreign Policy, and the Global Mind Dead Award for Arts and Education in 2019. In 2019, Leslee was awarded the UN Women for Peace Activist Award at the UN Association, USA's Global Citizen of 2019, and the Gandhi Foundation International Peace Award. A former filmmaker and now campaigner for a system change on education, Leslee is no stranger to successful campaigning films. Who Bombed Birmingham for HBO and Granada TV directly led to the release of the Birmingham Six after 17 years of wrongful imprisonment. Her feature film, East is East, won 35 prestigious awards worldwide, including BAFTA for Best Film. This film did much to promote tolerance and the celebration of diversity as between the Asian and British communities, and has become a classic film taught in schools across Europe. Her documentary, India's Daughter, has been critically acclaimed around the globe, won 32 awards, including the Peabody Award and the Amnesty International Media Award for Best Documentary of 2016, and sparked a global movement to end violence against women and girls. The searing insights yielded by the 2.5 journey making India's Daughter led Leslee to found 2.5 years journey making India's Daughter led Leslee to found UK and US-based not-for-profit global education initiative Think Equal, of which she is the CEO. This early years education program, the solution to the problem the film laid bare, is currently impacting 39,850 young children in 14 countries across 5 continents. Partners of Think Equal include UNICEF, UNESCO, even Pope Francis, Pope Francis's scholars. The AC Milan Foundation, you can see it's very diverse, Montessori, the Institute for Healthy Minds in Wisconsin, Madison University, Charter for Compassion, the Dalai Lama, Emory University's Social Education and Ethics curriculum, and the Yale University Center for Emotional Intelligence. So Leslee, tell us.
Well, that's exhausted me. I don't know about everybody else. But, you know, if that sounds like a long and impressive list of awards, let me tell you that I've set my bar even higher for this webinar. And if I cannot persuade you, Dr. Laibuta, to amend that child bill for Kenya and bring in what I consider to be a human right of our children that is not yet enshrined in any framework of law, then I will have failed. So please be persuaded. Look, the first thing I want to say is how thrilled I am to be here and honored, because Saudamini and Veronica, Dr. Laibuta, Declan, Sheila, you do extraordinary work, and I'm in awe and great admiration and respect of all that you do. I want to talk in my 10 minutes about prevention and about our culpability, our responsibility in human rights abuses, because I genuinely believe we, every single one of us, are responsible for abuses of human rights. I want to just mention an image that haunts me every single night, that I cannot get out of my head, and that I saw on television. I think it was about 3 weeks ago now. Do you remember in Afghanistan, very recently, there was an atrocity, a planned terrorist attack, and this time the attack was planned and carried out on a maternity hospital. And newborn babies died in large numbers, and mothers who had just given birth or were about to give birth, and fathers died in large numbers. And there was this image of a soldier, a man with a gun, running out of that maternity hospital, cradling a newborn baby in his arms. And that just epitomizes for me our shame as human beings, and the reason why we need a new humanism. We need it urgently. And we need each and every one of us to be active participants in crafting that and making damn sure on a very active level, not a theoretical level, not an academic level, and with the greatest respect, not even a legal level. Because the truth of the matter is that culture trumps law. Sorry to use such an unfortunate verb. Culture trumps law. So we can have all of the frameworks and you know, laws and charters and codes and conventions. Now we have the Human Rights Declaration. We've had it for 72 years. I just want to, because I am focusing on prevention, I want to look and actually read out to you, if I may, what Article 26 of that, you know, venerated and respected and fantastic Declaration of Human Rights for us all says about education. And why have I chosen education? Because ultimately, if culture trumps law, then it's the discriminations, it's the mindset that lead to the violence that are the real disease. The disease is not the violence, is not the abuse of human rights. It's what leads to those. Those are the symptoms of the disease. And the disease is discriminatory mindset. And in a moment, I'll flesh that out and make it less theoretical and tell you how I discovered that to be the case briefly. But how can we change mindset? How else can we change mindset but through education? The question is, what kind of education? Now, we know what kind of education. We've known it for a very long time. Let's take a look at what Article 26 of the Human Rights Declaration says about education as a right of every child, what that education must encompass. It says, education shall be directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. It shall promote understanding, tolerance, and friendship amongst all nations, races, or religious groups, and shall further the activities of the UN for the maintenance of peace. Nowhere there do I see that education shall encompass, from a human rights perspective, those competencies and skills that we are so obsessed with teaching our children because they lead to what we perceive to be a good place in the labor market, a good job. Numeracy, literacy, testing, that's not education other than for a very limited purpose. The education that we need for our children and that I believe should be encoded in our statutes, in our laws, and should be made compulsory as an expression of our duty of care to our children, which clearly we have. That is why they're defined as children, because they require care and intervention and protection. And we are failing our children and have been neglectful of our duty of care for them by allowing there to be a missing core fundamental purpose of education, the missing subject, the missing third dimension, which I call social and emotional learning. Teaching our children how not to grow up and rape, how not to grow up and commit suicide or suffer from depression, the number 2 disease we have now in the world. Suicide, the number 1 killer of young men in the UK, where I'm situated now. Rape, 1 in 3 women and girls across our planet. I mean, we know all this. We are so aware of it that we're actually becoming inured to it. We've normalized it. And I maintain that until and unless we bring to the core purpose certainly of early years education, and by early years education, I mean prior to the age of 6, the core purpose of early years education, whilst the personality of the child is being developed, must be enabling that child to fulfill his or her potential as a dignified human being who respects the dignity of all others, who will not grow up to commit human rights violations. Because the way we treat human rights violations, and we should hang our heads in shame about this, is we deal primarily, we put our resources, our energies, our concerns into the fallout from human rights violations. What we should be doing is, of course, dealing with that because we have to. But what we are not doing and must start doing really seriously is to prevent our children from growing up to become perpetrators of human rights violations. And I'm just going to end by very briefly telling you, because I don't want you to think, you know, I've come to this from some kind of research or theoretical position. I came to this because I sat for several hours in jail cells, prison cells, with the perpetrators of the most extreme violations of human rights. 3 gang rapists who had gang raped a young woman on a moving bus in it doesn't matter where, it happens all over the world, all the time, every day, who had gang raped this girl until her intestines were hanging out of her body, and they then threw her to die on the side of the road. I interviewed one man who had raped a 5-year-old girl. And when I asked the rapists of the young woman on the bus why they were expressing no remorse, no regret, they basically explained that they genuinely didn't believe they had done wrong. That girl, they said, had broken all of the dictates of patriarchal society. She was out late at night, that makes her a bad girl. She was with a boy who wasn't her husband or her brother, that makes her a slut. And they said not only did she deserve what she got, but they had a duty to teach her a lesson. That is what they told me. And in 31 hours of interviews, they expressed not 1 second of regret or remorse. And the guy who had raped the 5-year-old, who didn't, of course, have the excuse that that 5-year-old was out late at night or breaking the regulations that are reserved for girls and women in some jurisdictions, or cultural, socio-cultural jurisdictions, because this has nothing to do with the law. It has everything to do with culture. He had not that excuse. So what did he tell me was his reason for feeling no remorse or regret? He said, word for word, he said, she was a beggar girl. Her life was of no value, quote unquote. We in socio-cultural programming are teaching our children the kinds of discrimination that are fueling human rights. When I sat for 31 hours with those perpetrators of human rights violations, I was absolutely clear. There was an inevitability about what they grew up to do, because we had taught them how to think, and in teaching them how to think, actually we're laying the foundation for their later actions. So to sum up, Think Equal is an incredibly practical, concrete, replicable, scalable, and free to the point of direct costs of printing and production of materials, etc., so that it'll scale. And it is a program that says, without active and universally achievable, so that there is an equality of standard of teaching, so that we're not relying on, particularly in the early years, by the way, where we've been treating the workforce as babysitters and have not skilled or respected or paid our workforce enough. We can't necessarily expect all of our early years practitioners to be trained, competent, brilliant enough to know how to mediate the competencies and skills which are critically important, like empathy, gender equality, emotional literacy, emotional self-regulation, peaceful conflict resolution. I could go on. I'm not going to because I don't have time, but www.thinkequal.org will have, you know, the whole list of the 25 skills and competencies that we directly teach in Think Equal. And it is our responsibility to teach these in a concrete way and in an instructional, prescriptive way. And we have to get in there with our children before the age of 6. Because if we believe science, as we proclaim to do, we proclaim to respect neuroscience, for example, greatly. Well, neuroscience is very clear that to put in the foundation for the rest of one's life in respects of activity in the developing brain and the physical architecture of the brain, literally the furniture of the neural pathways in the brain, by the age of 6, trajectories of habitual ways of responding, of emotional control, empathy, flatline. It's very difficult after that. And why in God's name would we be so irresponsible to build the building from the ground or even first floor up without putting in the foundations? Why would we spend our efforts, our time and our energy in trying to undo the bad wiring, that socio-cultural thinking with all of its discriminatory mindsets, attitudes, behaviors that parents are passing down cyclically and generationally to their children because they haven't learned any better? Why would we rely on trying to undo those later in life when we can actually build the child with the foundations of a global citizen who loves, not hates? Mandela said, no child is born hating another human being because of the color of their skin, their religion, gender, any other background. A child has to be taught to hate. And if he can be taught to hate, then he can be taught to love. The very last thing I want to do is quote Mahatma Gandhi, another great man, who, apropos of the last sentence of Article 26 of the Declaration of Human Rights, which says that education shall further the activities of the UN for the maintenance of peace. Gandhi said, if we want to achieve real peace in this world, we will have to start with the children. Thank you very much for joining us.
Thank you so much, Leslie. If we want to achieve peace, we must start with our children. And I think that is something all our panelists have been saying in one way or another. We must recognize our children, all children. We must not discriminate. We must make sure they're not victimized. But we may have all the laws in the world, but if we cannot change the mindset, then we cannot achieve peace. We will all remain culpable if we do not take action. So thank you so much, Leslie, and everybody else. Leslie, maybe you could just tell us very briefly in 1 or 2 minutes before I hand over to Declan. At Think Equal, you are instilling human rights values from the early age. Can you give us a small example of maybe the content or how you do it? Very briefly.
I'm going to give you my favorite example. And it is to do with discrimination. And it actually is so important to us. It appears in Lesson 1, Week 1, Level 1. Level 1 is for children of 3 to 4 years old. Level 2, 4 to 5. Level 3, 5 to 6. And then we stop, not because one shouldn't continue, of course, but because we have limited capacity, energy, and time. So in the first week, we have a book, And each week we actually have a book which we've created, which is a narrative picture book, which excites empathy and storytelling and character to engage the children. And each book floats the theme or themes of that week. And then we have 3 lesson plans, which are absolutely clear and prescriptive and easily implementable by practitioners, which work on, with art, with music, in various ways, work on those themes. So we have 1 portrait, which goes with the book Me, Myself, and I. The book Me, Myself, and I shows people, we actually re-illustrate it for every country, but we ensure that we show people in all of their multi-colored glory. And we have a beautiful little portrait which was created by an artist called Jaslika Associate, which has 6 color tones of skin on them. And at a certain point in the book, the teacher has read out, I love my hair, my eyes, my skin, because this is a book that's celebrating me, but me is the different me's that exist in my world, in my country. And the teacher then is instructed or invited to ask the children to have a discussion about hair. Do we all have the same hair? Now, clearly looking around, I can only see the panel. We don't have the same hair, and the children come to that conclusion, and they then are asked to discuss the various kinds, lengths, textures, colors of hair we have. We then do the same with eyes, and then the teacher reads again, you know, I like my hair, my eyes, my skin, and asks the children, do we all have skin? Well, yes, the children come to the conclusion after discussion, we all have skin. Do we all have the same color skin, asks the teacher. And even if it's a homogeneous classroom where children do have the same or similar colors of skin, the teacher has her little 6 portraits of different colors of skin from around the world. And she will point at somebody who is, let us say, Saudamini's color, and ask the children, what color is she? You can bet your bottom dollar that the children will come to the conclusion that Saudamini is white, and they would probably say the same thing about me. The teacher will then take a piece of white paper and ask the children what color that is. They will look at it and say, ah, that's white. She'll then put that white paper against the portrait that is Saudamini's color and ask the question again, is Saudamini or this portrait white? Well, of course it's not white, because if you look at Saudamini's face or my face, you know, white simply doesn't match me. These are different colors. We'll look at a portrait of a child who looks perhaps like Declan, if I may use you as an example. And we ask the children, so what color is Declan? And you can bet your bottom dollar they will say, black. Declan is black. Okay, asks the teacher, if Declan is black, can anybody tell me what color is Declan's moustache and beard? And the hair we can see of Declan's. Well, of course, that is black. Yes, so if that's black, then Declan's skin is not black. So we are actually starting our children off with very divisive labels. Very soon, those divisive labels are going to mean a great deal as language and culture intertwine when children start learning idioms and metaphors like the black heart of the villain, the white angel from heaven, the black sheep of the family, a black mark against your name. We could go on. What are we teaching our children? It is not true that I am white and Declan is black. Every single one of us is brown, and the teacher proves this to the children with one brown crayon. So they see with their own eyes that we are one family. We're just different shades of brown. So that is the kind of teaching. It's always concrete. It's always positive and truthful and accurate. And a child that learns that at the age of 3 honestly cannot grow up and, you know, have a view about characteristics pertaining to Black people or brown people or white people. Sorry, that was a long example. Perhaps I shouldn't have chosen my favorite one because I was bound to speak long about it. Thank you for bearing with me.
Thank you, Leslie. Well, that's food for thought. You know, but I think the bottom line is we are diverse, yet we are one human family. I think that is the message. That,
the message Sheila,
yes.
can I just say, here is a beautiful example where something that started in the so-called, you know, West. I hate these border divides between us as well. We're a global family, but actually has taken its philosophy and its foundation from Africa. In this case, we have 4 of you who are from Africa, and it's pure Ubuntu. You are the other me, and I am the other you. And if we hold each other to be of equal value, then human rights violations fall away.
Thank you, Leslie. I think that's an appropriate, not the end to the webinar, but end to the panelists. But I now want to hand over to Declan to take us through some questions. We may not be able to ask all the questions today because we don't have a lot of time remaining, but we may go over by a few minutes, let's say 10, 15 minutes. But there are people who want to ask some questions, and Declan, maybe I can hand over to you for that segment of this webinar.
Thank you, Doc, for that. Yeah, so after such deep insights on various topics, I think it would be helpful to respond to some questions, even to gain ability. I'll push the first question to Veronica, who talked more on the invisible child, quote unquote, and this is matters intersex children, and the question is from Naum, who's based in Nairobi, and she's asking, what is the government doing to enhance intersex children education rights? And what boarding schools, for instance, are they being admitted in? Veronica?
Thank you for that question. I would want to first state that prior to COVID-19 pandemic, the Intersex Persons Implementation Coordination Committee and also the National Commission on Human Rights had already begun engagement with Ministry of Education with regard to addressing cases that were brought on board of children, to be precise, 6 children who are intersex children, and they were having difficulties transitioning from primary school to secondary school. So all 6 cases were assisted, and these children are now in the right schools or in the comfortable and secure schools. But with regard to putting in mechanism that is sustainable, the committee is working closely with the Ministry of Education and the Office of the Attorney General and other actors, including the civil society organization that works with intersex persons, to develop guidelines that will ensure and enhance inclusivity and access to education for intersex children across the country. Thank you.
Yeah, Veronica, if we can push further. Are there some, and this is a question from Jasmine in Nairobi, are there some programs in place to sensitize the public, especially teachers and caregivers? And you did give us the example of a caregiver mentality, which was wajinga, or ujinga, which indicates very, very negative view of this matter. But so to that effect, are there some programs to sensitize the general public?
Thank you. For the question again, yes, there are programs that have been developed to address and to sensitize the gap to address the public and sensitize the entire public, not just the intersex persons community, but also the different actors, the professionals. And what we had done initially, that is from last year, December, up to February this year, the committee had already started regional engagement. These regional engagements were mapping out the different caregivers, both in schools, the different duty bearers we have, the community, by holding dialogues, regional dialogues, which were helping in terms of just first and foremost, helping the people in the different counties, that is the 12 counties that we targeted, to start the conversation about the plight of intersex persons, the challenges they face, and also I agree on how do we move at the county level. What innovations can we bring on board to increase the advocacy for the rights of intersex children? Yes, there are programs, and even as we go on, they'll be seeing a lot of webinars speaking to the public, but also we have also developed IEC materials for the public use. So beyond that, I believe even beyond COVID-19, there's a lot of interactions with the public and the different stakeholders that are already scheduled. Thank you.
Great, and maybe we can just keep it still. We're going through a global pandemic, COVID-19, and we've seen increase in gender-based violence and violence against children. For instance, have we noticed any evidence in increased violence against intersex persons?
Thank you. In terms of violence perpetuated against intersex persons, so far we have not received any gender-based related case or complaint. But what we have also done, noticing that this pandemic brought about an emergency situation and different measures were put in place that again were based on the discriminatory laws that are already in existence, we as a committee and also as a commission, we have been monitoring the different, the impact of COVID-19 to the families of intersex persons, but also monitoring the cases that are being reported. So we have been using an SMS number that is 22359, which we have really encouraged the persons, the intersex persons, the public and the stakeholders to really reach out when they have an issue. So far, we have received 36 cases from the intersex community. I would really I shock you by just indicating that out of the 36 cases you have received, 33 cases are raising concerns about the lack of survival or the lack of ways or means of fending for these intersex children and intersex families. And this is again is an impact by COVID-19, where most of the family intersex households are single-headed families, and the stigma and the mental fatigue that comes with raising a child sort of leads to the single-headed families. And also the levels of economic empowerment are really low. So the 33 cases we have received so far speak to lack of food, lack of access to those casual jobs, and also some of them have been sent out of their homes. So we are working closely with the organizations that support intersex persons to provide some of this food, to provide some of this money for rent, and also medication. But beyond that, what we have also done, focusing on the responsibility of the state, we have also activated follow-up mechanism to ensure that intersex persons are also remembered or they are acknowledged when it comes to equalization social protections initiatives, which other vulnerable children benefit from. Thank you.
Thank you so much, Veronica. I'd like to engage Dr. Saudamini a little bit. Dr. Saudamini took us through matters transitional justice and the importance of transitional justice. And the first question I'd like to ask you, Dr. Saudamini, is what you did indicate your extensive experience in various countries and jurisdictions as far as children and transitional justice is concerned. Amal Mohammed from Nairobi is asking, is there a best standard for successfully involving children in reconciliatory process in any of these countries? And how did they achieve this? How did this particular country achieve this?
Okay, thank you for the question. What I will say initially is that there are good practices. We can say there's a best practice because in each situation, it requires the specific context to be taken into consideration and to reflect the experiences of the children, their families, and communities. You know, I mentioned the Sierra Leone case, and I mentioned also the case in Nepal, where a truth commission was not pursued or has not been as yet, but a national dialogue was pursued. Recently in Sri Lanka, we were working with local national organizations, building capacity around specifically reconciliation in the aftermath of a conflict. And that has been also quite, I would say, successful. In each of these cases, the process continues. So it's a pursuit of reconciliation that is ongoing. Thank you.
Cool. If I could segue into another question from Iqbal in Nairobi. Do the victims demand any form of accountability based on your experience? Do they demand any form of accountability or justice for what they've suffered? Yes,
that's a huge issue. I mean, the example that comes to mind there is the case in Uganda, where there was quite a strong debate about whether the mechanisms to address accountability would be best to follow the traditional Matu Oput reconciliation process or to pursue criminal prosecution and accountability. And the victims, you know, again, there's no one answer because there were diverse positions and opinions. But in some cases, in particular in that situation, some of the victims really were adamant about pursuing formal criminal prosecution. That isn't always the way to have impact across community and to pursue reconciliation. So that judicial and non-judicial pathways towards accountability and towards reconciliation vary. I mean, the situation also in Colombia and the children's involvement in that conflict led to also debates about that responsibility or potential accountability for one of the longest conflicts, you know, in history, and that the involvement in children in the process now in the aftermath of that conflict, it's complex. In particular, the reparations programs have involved children. So there is a different, let's say, palette for pursuing accountability in each case. Still today, the situation that was pursued in Sierra Leone introduced quite a lot of new precedent, both in terms of the non-judicial Truth Commission accountability, as well as the criminal prosecutions that were through the special court for Sierra Leone. So that range of possibilities for reconciliation is specific to the context. But it's very interesting to consider education. And this was mentioned also by our other panelists, how important that is in building reconciliation over the long term, in ending, you know, and preventing non-recurrence. That's really, I would say, a very important key, you know, in how the next generation can learn from the past in order to prevent recurrence of violence. How do we do that? We have to do that again through education, both informal, community-based, but also formal education in the schools, so that we learn what and how to build a peaceful and stable society with the full engagement of the communities who have been affected, both as victims, but also as perpetrators, so that we can come together.
Thank you so much, Dr. Saudamini. I'll move on to Dr. Laibuta. Dr. Laibuta took us through, policy and advocacy, and he talked about every child, every right as a golden string that cuts across all these legislations. And the question I'd like to ask you, Dr. Laibuta, is from Amal Mohammed in Nairobi, who says, following the publishing of the latest report on children in the justice system in Kenya and your work in the Children Bill, what is the biggest obstacle for children in the justice system? And that's probably a Kenyan perspective and maybe some global insight, global trends as well.
Thank you, Declan. I think the biggest hindrance framework. Indeed, even though we have had the practice of diversion practiced in our children's courts, we haven't had a set of court rules and regulations that define a step-to-step practical approach to diversion. What we've had are standard operating systems, of course, which do not carry the force of law. But for the first time now, after the enactment of the bill and the draft rules and regulations that we have in place right now, waiting enactment of the Children Bill 2020, we will have a defined legislative, both substantive and subsidiary frameworks for child justice. There was an attempt some years back to come up with the law, with the statute law on juvenile justice way back. I think it must have been around 2014, 2015, but it was felt that the trend in Kenya was to consolidate the law relating to children matters. That is why we had the 2001 Act earlier on, repealing, say, the Adoption Act, Guardianship of Infants Act, the Young Persons Act, and various other segregated pieces of legislation that dealt with different matters related to children. The consolidating statute law, of course, fell behind times with the promulgation of the constitution that is in force presently from the year 2010. So it became necessary to reform the law and have yet another consolidating statute, the Children Bill that we are dealing with right now, that is just about to be presented to Cabinet for approval, and then take on the usual legislative process of publishing public participation through the various parliamentary committees, and eventually enactment. Once that is done, then we will have also a defined regulatory and framework for rules of procedure in various courts to deal, not just with children in conflict with the law, but on all matters that affect the children: adoption, foster care, guardianship, care and protection, children institutions, and so forth. So we are just about there, but of course we've had quite a number of impediments. The sector that deals with children matters attracts a lot of interest from various state and non-state agencies. Individuals, of course, who have their funded programs that draw funds from various sources to run programs for children in care and protection and so forth. And there was the push and pull as to who should have power to do what. Of course, every player wants to have a lead in doing what has to be done. But that pulled us back for a while. But I think we've broken through that impediment, so we'll have a well-defined legislative framework.
Oh, great. Another quick one, Dr. Laibuta, from Togori Mathenge, who asks, there has been a normative lack of clarity on whether the best interest principle is applicable in criminal proceedings against children. Is this really applicable?
No, that's a misconception. In fact, if you look at the diversion procedures and also the justice system that deals with children, whether they are held in remand homes or rehabilitation schools, or children accommodated in children's institutions for whatever reason, trust me, the standard set now, if they go through Parliament with these draft pieces of legislation, we will have at every stage considering the best interest of the child. We do this because we believe that children have special needs. They need to be treated not as not as criminals when they offend. They need to be corrected. They need to be guided, and that's why we do not even talk of them as criminals. We don't talk of sentencing them. We don't talk of convicting them. But the approach always is to reform the children and guide them to grow and develop. However, what Leslie presented here is fundamental for all of us to take note of. Some of the children grow in very disadvantaging environments, and to shape them using law and programs becomes very difficult. So we know that there are those in respect of which it is too late to have corrective measures, but we nonetheless try to come up with legislation that is leaning toward, that leans towards correction, reform, rather than retribution and punishment.
Thank you so much, Dr. Laibuta. I really appreciate your response. I think I'll move next to Leslee Udwin. I personally had the privilege to actually work with Leslie, and we continue working. And I'm sure Leslie will also be very happy to hear that Dr. Laibuta picked an insight from her presentation. And first question to Leslie.
All my awards. That's all I needed to hear. Dr. Laibuta, thank you. That's what matters most.
Great. Yeah. So Justice Martha Koome is asking Leslie, and the question is, how do you ensure the teaching done children in Think Equal are carried out adulthood in the midst of a strong culture that trumps the law?
I need you to repeat that because the sound was not great. How do we ensure in Think Equal?
So I'll take that again. So Justice Martha Koome, who's based in Nairobi, question: how do you ensure the teaching done children in Think Equal are carried out through adulthood in the midst of a strong culture that trumps the law?
Thank you. A very persuasive question. Now, how we ensure is through the simplicity of the science of brain development. There have been many, many studies. And by the way, anybody who's interested in seeing them, I will send you happily a summary which we have, which is incredibly thick. There have been many studies which show that when you teach social and emotional learning in the early years, this does form a foundation for later behaviors. And it predicts the perpetration of crimes in adulthood. So, for example, a child who has had significant and quality social emotional learning in its early years will be 86% less likely to ever come into contact with the police than a child in a control group, which is not. Academic marks themselves rise by 17%. So this should be very motivating and persuading to parents. there's evidence, there's scientific evaluations and evidence that it lasts. And it's not surprising because 95% of the human brain is fully developed by the age of 5. And these neuro pathways, which are set for pro-social or anti-social behaviors and attitudes, are set by that point, which is why I believe we are actually certifiably insane to try and spend our energies undoing that set pattern rather than creating it right in the first place. And another aspect, I think, implied at least by your question, is what happens to those children who we teach these wonderful pro-social, caring, compassionate, empathetic ways in their classroom communities, and they go home and they are immersed in or witness to or victims of the kind of human rights abuses that take place in homes by these adults who have not had the privilege or care shown to them for them to have learned how to value themselves and other human beings. Well, what happens is that the children go in knowing that what they are seeing is wrong. And if I could tell you, and of course I won't because it will take so long, I've got hundreds of examples from the 14 countries in which we're working with Think Equal in some stages, rolling out, of children who go home and teach their parents, and successfully so. So the thing that I was terrified of was that we would have cases of parents coming to the teachers and saying, what the hell are you teaching my child? I don't want my child to learn to love the Tamils or the Sinhalese, or, they killed my child's whatever it is, it's not happening. And actually parents are coming and saying, we want more of this, because they do. All parents want their children to thrive and, to grow in good and fertile and supportive soil and not commit the same mistakes as their parents have. It works.
Oh, great. And probably you've already alluded to this, but if you can delve deeper. Changu Manatoko from is asking, how do you factor in patriarchal culture, neocolonialism, and South-North power dynamics that have a role in promoting child rights education?
So what we teach is that each and every one of us is of equal value. Now, when we're dealing with children between 3 and 6, we don't teach the misdemeanors and crimes of the past. We are basically building a present, a community of care and love and compassion for our children in their classrooms, hopefully in the homes, although that is a much, much tougher task. But we don't dwell on how things have been bad. These are 3 to 6-year-old children. We are dwelling on how they should be and how human beings are at their best in all their diversity and so in a sense, we are building by example, we are building by instruction and immersing the children experientially in what is good and what is right. Now, as far as breaking patterns is concerned, when children learn that I, as a girl at the age of 3 to 6, can be anything I want to be. I can be an astronaut, and I know this because I'm shown, and I'm playing games with occupation cards that are showing me a girl astronaut and a boy astronaut, and a girl scientist and a boy scientist, and there is no question There's no questioning that there are patriarchal restrictions on me because of my gender. Well, that is how we're going to break patriarchal values and a system of patriarchy that results in a soldier coming out of a maternity hospital with a little baby, newborn baby in his hands and a gun in the other. That's how we're going to break that. But it's the only way I know of to break it. And that is why that's what I've given the rest of my life to.
Thank you so much, Leslie. Much appreciated. There's one adding question. I'll push this question to both Saudamini and Leslie. So the question is from Shamim Juma in Mombasa County in Kenya, who says, we are struggling with children in conflict with the law. They have no sense of remorse to attack and harm anyone. Now that the damage is already done, what should we do? So, Saudamini, if you don't mind, you can pick part of the question and you can also make a comment in a minute, if you don't mind.
Okay, thank you. That's a very tough question, and there is no one answer. I think that, you know, what we're talking about here is how do we make that transition from conflict, war, from the repetition of our human history to actually teach peace, as was mentioned. And does justice contribute to reconciliation? Is justice necessary for peace? And what does justice mean in a particular community? And when children are involved, when they've been recruited and when they've been influenced to take part in hostilities, then how can we recover the humanity in the community in which they live? And indeed, accountability is a part of that. And most significantly, reconciliation and the recognition of our common humanity. How do we teach that? How do we approach that? There are many efforts underway. Again, we can't give up. Too much is at stake. We're living in a very divided world right now, and we need to find ways to come together. So to bring children out of those very extreme situations of violence, there is the necessary process of relearning of both the psychosocial support, but also the education to relearn the values of the community, to recognize the common humanity. I mean, in that specific situation, it's not the only one. It's happening in so many situations, in so many countries, in particular where extreme violence has been used and children have been actually exploited because they're vulnerable, because they don't have necessarily the situation where they can resist, and either forced or forcibly recruited. So that requires a community-based approach. It's a very long process for recovery. Thank you.
Leslie, any insights?
I think Saudamini has said most of what I believe also, and very eloquently. So I'll just keep it very short. I think one of the first things we should do is look at them as human beings and understand what has happened to them. What have they been through? What adverse childhood experiences are they victims of? What sociocultural robotic programming have they been victims of? Because a child, by definition, is someone in need of care and protection. And if that child has perpetrated a crime, the first thing we have to do is be understanding and look at that child from a human lens. And I'd be amazed if there are cases in which we cannot come to understand and forgive that child. And we should see, as I say, we should see our responsibility in teaching that child that the person or persons against whom he or she committed these crimes were lesser to them in some way, or subject to different rules, or whatever enabled them to other this person, because if they saw that person as of equal value to them, they would not have committed that crime, quite simply. So I think, you know, back to what, you know, my mantra is just prevent, prevent, prevent. It's so easy. It's so ridiculously cheap. I'm dealing right now with a rollout in South Africa, working with the South African government and the early childhood department. And we've just budgeted, because we are rolling out to every 5-year-old child in South Africa. They start school later there, so we can only begin at 5. It's $2.5 million to give this program 3 times a week for 30 weeks for an entire year to every single 5-year-old in that country. How dare we not do this? How dare we stand in the way as governments or, you know, quasi-governmental bodies, which happens all the time in this struggle to give the children what is their fundamental right, the right to a foundation for positive outcomes in life.
Thank you so much.
I just add one more point to that to increase the complexity, because when we were working with the Truth Commission in Liberia, well, the position was that children should not be subjected to judicial accountability. They should not be prosecuted for the crimes of the war. But some of the commanders spoke out and they said, look, we were recruited as children too. And we were also vulnerable. We just happened to have lived a little bit longer while the war continued. What about us? We also want to be forgiven. And we also want to be brought back into the community. I'm generalizing here to make the point, but the point is that we are all human beings, as Leslie was saying, and we have to really remember that in order to pursue non-recurrence, in order for prevention and recovery as well.
Declan, could I just a quick comment on this?
Yes.
I think in the end, it really depends on what program every country has for reintegration of child offenders in society. You could go through the restorative process, but how do you reintegrate them into the family, into society? And that calls for effective programs that I believe can be suitably defined, designed to bring the kind of corrective ends that we all look to. Thank you.
Thank you very much. Lots of questions we had from participants, but the ones we did ask were the ones we could just very quickly. These questions will be published and even given as well. So if you asked any question and it wasn't covered, don't worry at all, it will still be covered. So I'd like to pass this to Dr. Sheila to carry on, but thank you very much to the panelists for being very generous with your responses.
Thank you so much, Declan. Thank you. I'm looking at the time and we've gone over time. So I'm just begging your indulgence for a few more minutes to give us time to wind up. As Declan said, some of the questions that were asked, not all could be, we could not accommodate all of them now. And there's some, like there's one by Dr. Felicita Juguna from WORK, Women Educational Researchers of Kenya, who asked a question which was already answered through, I think, the question that was asked by Justice Martha Koome and partly by Dr. Changu Manathoko from Botswana. So, but we will share these questions, the remaining questions, with the panelists and ask them to respond in writing, and they will put them up on our blog post. Now, like I said, it's been a very, I think for me, it's been a very educative webinar. And some of our viewers who have commented, they're saying they've learned a lot from it. So thank you, all of you. Without taking any more time, I would like to ask each one of you to make your closing statement in 1 minute, please. So I will start with Veronica. She's been quiet for a bit. So let me start with Veronica.
Thank you, Dr. And thank you to everyone. First, I think I would want to just have a clarion call, just encourage every one of us that we have an obligation to defend human rights. And as such, as stakeholders, we can ensure that the communities and the societies where we live in are inclusive and are favorable to the welfare and enjoyment of human rights for the intersex persons. And I will also encourage each and every one of us to remember Mother Teresa's quote, that if you judge people, you have no time to love them. So this is to encourage all of us. Let's love every other person. Let's love one another. And as we do so, we shall then enhance the realization and enjoyment of human rights for all. Thank you.
Thank you. Thank you for that, Veronica. Let's move on to Saudamini.
Thank you. And maybe just as a last thought, I would say that in the aftermath of armed conflict and extreme violence, we hear the cry, never again. You know, this has been the kind of cri de coeur, never again, non se mas. And we see the recurrence again and again. So how do we really put a stop to it? What is the way to achieve non-recurrence? Certainly all of these components are important because we know the root causes of conflict are the inequities and the injustices, the discriminations of our world. So this is a long journey, and we are basically, you know, in the journey together. We have to work together. We have to find solutions, and those solutions are local. They're also global, but we really need to work at the grassroots level. And I think children and young people are incredibly important partners in that. And they've again and again shown their capacities to really make a change. It takes time. We were just hearing about reintegration. That's a very long-term process, which requires a lot of resources. So that's what we're facing, a big challenge, and we're meeting the challenge. Thank you.
I think, I don't know if we lost Dr. Sheila. I'll probably...
I think it was my microphone was muted. Oh. Sorry about that. Dr. Laibuta?
Thank you. Let me just end by saying this, and I do appreciate what my colleagues have said ahead of me, and I'm also privileged to have been part of this panel. But let me say this in conclusion. Our social accountability for the best interest of the children that are our children is a responsibility not just of government and ministerial or state departments, not just the non-state agencies, the non-governmental agencies, not just charitable institutions, but each one of us, including members of the panel and the audience. And the question we must always ask ourselves is what we do every day that touches on children, the best interest of the children, or for our business interests? Once you answer that question, you'll find either you are for the children according them every right, or you will be those who break our children even before they attain majority. Thank you.
Thank you. Leslee.
So I'd like to direct my last words to the people who are with us here on the webinar who have young children or know young children, and I'm sure that that means every single one of us. So the first thing to say is Think Equal, in response to COVID-19, has rather quickly gotten together a free giveaway to parents and children at home at this time of 6 weeks worth of activities and narrative picture books that address some of these social emotional learning competencies and skills. We've also written a book about the pandemic to explain these big feelings of confusion and fear and sadness to our little ones. But I wanted to say something actually quite serious to each and every one of you, and it leads on very much from what Dr. Laibuta has just said. A call to action, really. We are all guilty now of, and in a way it's not our fault, we've also been programmed to this because we've been told consistently by the world that the purpose of existence is accumulation of wealth, that great lie. Now, what grips us is what Pope Francis very eloquently calls the globalization of indifference. That is what we are guilty of or in the grips of. We see violence now, we've become inured to it. We become indifferent to it. We see human rights abuses with our own eyes. Each and every single one of us, as Dr. Laibuta said, has a duty, an accountability, a responsibility. And if it's only going to our school and saying, we don't accept that numeracy and literacy and teaching our children to read and write alone is enough. We must holistically teach our children, and frameworks, early childhood frameworks are not enough. They don't cut it. We need tools. We need prescriptive, concrete, plug and play tools which do exist, and demand that all of our children are taught them, because that is our duty of care.
Thank you, Leslie. I think all of you have made a very passionate call for action, call for preventive measures, but we also need to have, together with prevention, we also need to know how to deal with what already exists. So I think we need something that is bottom up and top down, and the both must meet somewhere if we have to change this world. Declan, your final words, your final insights.
Well, I think it will be with awesome panelists. Veronica, I really appreciated the perspective on silence, secrecy, and ignorance, intersex person. Dr. Saudamini, the importance of in transitional justice. Dr. Laibuta, policy and legislation processes, and every child, every right mantra, and of course Leslie, your inspiration in human rights, values instilling, and also social and emotional learning. This will stay with me, and I think these are clarion calls that we ought to highlight all these really critical issues. Thank you so much.
Thank you so much, Declan. I think with that, I'll also thank each and every one of our panelists for responding to our call to be on this panel and inform us and to, in a sense, educate us on what is happening, what is happening out there, what is the different ways that we must address this problem of discrimination and violence and rape and exclusion. So I sincerely thank all of you, but I also thank our very wonderful audience, those who have joined us from all over. for being with us today patiently up to now. And those who had to leave for whatever reason, this webinar, the recording will be up on our website. So please watch out for it in case you missed part of it. It will be there. The Q&A will also be there in our blog post, the written responses. And I'd also like to let you know our next webinar will be on June 24th. And this one will focus on girls, women, and human rights. We'll have wonderful panelists from different parts of the globe again. And we will also have an expert interview on Friday with Dr. Pilar Aguila, who will be talking about something that's been happening, the huge forced migrant crisis from Venezuela, which is second only to Syria. 5 million people have been forced to migrate. And now in the COVID pandemic, it's even worse. So she will focus on education. Apart from that, we'll also have what we've started. We'll be having other expert panelists before the webinar on 24th. We will also have conversations with youth, which our youth associates from Jaslika will be conducting those interviews with the children's cabinet, the children's government in Kenya, the first cohort from 2014, the president, the deputy president, and so on. Leslie, I know you're looking like, what am I talking about? In Kenya, there's a children's government,